Are you done?
Yeah.
Okay, great. Now I think we'll move on to the cross questioning, if I'm not wrong. So, counsel for old lady will have 30 seconds to ask a question to the counsel for the driver, starting now.
Yes. As the opposite counsel mentioned, that it was a mistake and not intentional. Intentional or not, Radha was the one who still lost her life, and there is no amount of compensation or anything that we can do to help her family, which is in grief. And then the council also had mentioned that 20 families would have been in grief. Well, in this case, instead of 20 families, it is still a family which is in grief, and all of this could have been avoided if the driver had just checked the bus properly without before taking all these children on. So the driver is not only answerable to the Radha's family, but also to all the 20
Counsel, what's
children.
your question? What's your question?
Yeah. So my question is, uh, how does the driver uh, how does the driver plan on taking responsibility for the life of Radha and also almost
Okay, thank
endangering
you.
20 children?
So, counsel for the driver, kindly answer as to how your client intends on taking responsibility for the death of the old lady.
So and almost endangering 20 children.
Okay. It was the driver's mistake. Didn't check the malfunctioning, but uh, after it has happened, now he has tried to save the 20 children, and he has never thought that Radha would come in between. Yes, it is a it is driver's mistake, uh, but it we can't do anything right now. We can only give a uh, penalty or sum of amount to them. Um, because if he didn't do that, the 20 children would have also been gone. So I think that a penalty would be fine. A life has gone, we can't compensate it. But now he has saved 20 children. So I would feel a penalty would be.
Okay. Yes, counsel. Do you want a follow up? Why did you
Yes.
raise your hand?
No,
No,
I wanted
we
to ask.
won't. We won't be having follow ups. My question to the counsel for the old lady first. No, the driver is. So, you mentioned, counsel, over and over in your argument that there has been a mistake. Are you agreeing to the fact that the liability is on the driver, that the driver is guilty of having caused this murder? Is
Uh,
that what you are trying to establish?
yes, he is guilty, but this has happened because he had to save the 20 children.
Oh, okay. Okay. So, for the counsel for the old lady, so the council in their speech mentioned that intent is important, which is where I'm heading at. The driver in this case had no intent, had no agenda behind wanting to kill the old lady. When that is the case, how will you establish liability?
Uh, so the question is, how do I establish liability even though
Liability when there is no, so
when there is no intent?
when there is a crime that is caused, there has to be an intent that fuels the commission of the crime. When there is no intent here, how do you plan on establishing liability on the part of the driver?
As to answer your question, there was no intent to kill anybody or harm anybody. But then the driver has been hired by the school to safeguard these 20 children by taking them in their bus. Yes. So isn't it the driver's responsibility to check all the equipment which is there and then ensure that the children are safe? Well, yes. First of all, he didn't ensure that because there was obviously a breakdown, And second of all, in the process there was a death. So someone has to there was a death, that is Miss Radha, and someone has to take up the liability and own it, own forth to what the mistake has been made. And the only person who can do that is the driver, because he was the reason which the accident occurred in the first place.
Okay, okay. Thank you, Counsel. I'm sorry, but Kritika, did you ask a question in the cross examination? Did
No,
you ask the other counsel a question?
no.
Oh, I'm sorry. Do you want to?
Yes.
Please go ahead. I'm sorry I missed
Um,
out on that.
yeah, it's okay. Um, the accident has happened, but before the accident, there is a incident happening that the bus is turning left harshly, and that is a malfunction, and something is happening with the bus. So even Radha could have been a bit more careful while going, and or she could have been accompanied by some of the family members. So it is not her fault, but still she could have been more careful while walking on the road, that she knows the bus is coming, so she could have been more careful.
So can I answer that question?
Yes, counsel, go ahead.
Yes. So as you had mentioned that Radha should have been more careful. Well, she was walking on a road and she was on next to the pavement, which can be seen from the case because the case says it. He takes a sharp left. So so can the council answer how can a lady or anyone else be more safe on a road while they are so close next to so close to the end of the road? And about the fact where someone else can accompany her, well, she is an old lady, so do you mean to say that the reason for Radha's death is because someone else from her family didn't accompany her? It the no the fact still remains that her death was caused by the accident, which came from the driver not checking the equipment. And the council herself had said that there was a mistake and it was the driver's mistake.
Thank you, counsel. That concludes our first pair. And just for the knowledge of the participants, the two concepts that we're dealing with here are A, something called death by negligence. Here, the brake malfunctioning is amounts to something called negligence on the part of A, the school, and B, as a subset, the driver. So that's the concept we're heading at here. And that was what I was looking for, the word negligence. Very well done, both the councils. If we can have the next two participants, please.
So now I have finals for ABSAP. So can I leave and rejoin later?
Yeah, yeah, sure.
Yes. Thank you.
Can we have the organizers call the next two participants?
Yes, Judge. So the next participants will be Joel Ruben and John Nefimon.
Okay. So
Excuse me, sorry to interrupt, but did the previous two counselors close the statements?
where they? Oh no, I don't think so. Oh no, I don't think so. No. Organizers, aren't you supposed to remind me of all of this? I'm also marking simultaneously and I couldn't. Okay, we'll have the both of them go up again later, if that's fine with them. We'll just carry on now. Can now go back and ask them to come. Can we have the case 7 for these two participants?
Okay, I had a few doubts before I start.
Okay,
Are you the judge or are you the jury?
I'm the judge. India doesn't have a jury system.
Okay.
Well, it was abolished long, long ago. So the concept of jury doesn't exist in India. So I will be the judge. And as far as the format of the event is concerned, I'm so sorry it's getting a little messed up, but let me just quickly summarize it again. Participants will be allotted the case here in this one. So you'll have 3 minutes to as preparation time, and then opening statement 2 minutes each, and then the cross questioning session where each of them will ask each other questions, and then I will ask each of them a question, and then we conclude it all with a closing statement. So yeah, that's about it. So I think a preparation time has already begun. So at the 3 minute mark, the organizers will let you know.
Am I the defendant or am I the
Um,
prosecution?
what's your, in what order were you called?
I was called first.
So you will be the
Prosecution?
you will be the respondent. There is no prosecution, so this is a civil case. So you have petitioner and respondent. A prosecution is only in the case of a criminal case.
Okay.
So here, since your name was called first, you will be the respondent who is who will be representing the grandparents. The petitioner will be John, who will be representing the father. I think that means your preparation time is over. Can we have the counsel for the petitioner, the father, go up first?
Yes. So this case is basically an impossible, based on an impossible theory, where here the father is accused, but since in this particular case, a father can change the habit, addicted to alcohol by attending some seminars, and also it is not like good to have grandparents to take care the child, because grandparents are so old and they might be sick, and which is a big burden for the child in regards with studies. And also like grandparents won't know about the future technology, or how can we say, like the upcoming okay, maybe the technologies, so that the child will not be like mostly influenced in the society, or mostly accepted in the society. So it's not good to grow under a grandparent. And also I can say like uh, grandparents maybe like could can sorry, so grandparents can like give pave way for the children to go with father.
Okay. Thank you, counsel. Can we now have the counsel for the grandparents going up, please?
Yes, Your Honor. So now I would like to highlight the facts of the case of this tragic event that happened. The father is an alcoholic, a cruel man who tortured both his wife and child. The wife therefore committed suicide. And now the grandparents have taken him as they felt it would be safer for the child that he is with them. Now the father has filed a suit to take away the child. How can he, is my question. He is not mentally healthy, nor is he medically sane. He beat both of them under the influence of alcohol, and it's good for the child that he's with the grandparents because it's safe for him. Both physical and mental health will be taken care of by the grandparents. So this is my opening statement.
Okay, thank you, Council. I think we will now move on to the cross questioning that is between the both of you. So, if we can please have the petitioner, that is the counsel for the father, ask a question to the respondent.
So I have a question like father is basically addicted to alcohol, but he can change, right? There are many people around like they can change and get rid of alcohol and taking care of their family, and also the wives that may have been like influenced him. At least the children must be grown well. So why not like we can have a father to take care of the child? Because grandparents are like not known with the society as
Okay,
much as now.
counsel, please sum up your question. What is your question?
So the
Your
question,
question is why we're denying him the opportunity to be a better person, that he could be a better person. Though he is an alcoholic now, you're saying he could be a better person. Is that what you're saying?
yes, yes.
Uh, counsel for the grandparents, can you please respond?
Yes. Now, he has not shown that he is actually sane or he is mentally healthy at a medical level. There is no mention of him trying to reform himself, nor has he taken the steps to go to Alcoholics Anonymous or to gain medical help so that he can cure himself to take care of the child.
Thank you, counsel. Can we now have the respondent ask the petitioner a question?
The father cannot have the child because he is so cruel that he beat up the wife and she committed suicide. And he has not taken any steps. So, my question is, why hasn't he taken any steps to make sure that he's mentally healthy? And why hasn't he taken any steps to make sure that he's financially able to support the child? As a drunkard, I don't think any employer will ever give him a job.
See, like everyone makes mistake, right? And there are people who just come rid from the alcohol and takes care of the child.
Exactly, but he hasn't done that yet.
No, no cross questioning, please, counsel. Please
Okay,
let
I'm sorry.
the petitioner respond. Yes, yes, counsel. Please go on.
So like there are many cases like the father could change from the alcohol, but still it's not mentioned here. But every father has at least a small care towards the son, right? Any father will not be like just I don't need anything. I want to just drink. Who will be like that? Every father has some love towards the son, so I'm sure that he would take care of the son, and maybe the son would change the father and lead a good life, maybe.
Thank you, counsel. So, my question to the counsel representing the father, the petitioner, is so legally, after the death of the primary guardian, here the mother, the custody of a child will go to the surviving parent. So, on what legal grounds do you think? I'm sorry, this question is to the respondent. So, on what legal grounds do you think, as a grandparent, you can acquire the child when it is clear that the guardianship should only go to the surviving parent?
A parent is supposed to make the child feel safe both mentally and physically. He has not fulfilled those two duties as a parent.
Is that it?
Yeah.
Thank you, respondent counsel. So, to the counsel representing the father, the interests of a child, both mental, physical, and psychological, is of paramount importance. When that is the case, on what grounds can the grandparents trust the father to safekeep this child, especially when he has a history of dealing with alcoholism as well as domestic violence?
So like the court can announce like the father maybe like avoid alcohol for like 6 months maybe for practice, and then they might allow the child from grandparent to go to the father and live. Maybe that kind of condition is good, because like without having any evidence we cannot like just deliver if any suit was organized, right? So that's my point of view.
Thank you. Now, if we can please have the closing statements, we'll have the respondent go first with the closing statement.
Yeah. So, again, the facts of the case: the father is an alcoholic. He beat up his wife and child. The wife, in turn, committed suicide out of torture, and the grandparents have taken custody of the child now. The father has legal grounds to take the child back, but as a parent, he is supposed to fulfill these two duties: make sure the child is safe mentally, physically, and psychologically. He has not fulfilled this, nor has he taken any steps to reform himself, to make himself medically sane and healthy, to make sure that the child grows up to be a responsible citizen. What does an alcoholic parent teach his child when he still hasn't reformed? What would happen if he still beats him up later? This puts a huge pressure, and it can lead to depression for the child in the later life. His life would be ruined. And if he loved the son, he wouldn't have tortured the mother that he loved. And if he truly loved the child, he wouldn't. He wouldn't beat him up. And I feel sorry for the opposition that 76 million people are affected by alcohol disorders, and he is one of them. And many of them do take steps to reform themselves. As long as he is still like this, he cannot gain custody of the child under any ground. As long as he is medically insane, he cannot have custody of the child. He is safer with his grandparents. And even if the grandparents are sick, he will go to child services. The government will have him taken care of by foster parents. This system is a very good system in India, and the child will be taken care of better than under the custody of the
Thank
father.
you. Thank you, counsel. Thank you, counsel. If we can have the practitioner go up.
So again, the fact the grandmother is so old, and she is not aware of the recent development in the educational system maybe. So it is good to have the child with the father, and I'm pretty sure that the father would change by seeing the son's face at least, because every father has an attitude, whether they don't like the wife maybe, but at most they love their sons so much. So love is a very strongest barrier than anything else. So it is very much better to live with the father instead of the grandmother, because grandmother is so old, so sick, so the child cannot get a proper future maybe. So it is better to live with the father. That's my statement
Thank
on.
you, counsel. That concludes this round. And in case you guys are looking for a conclusive answer, in this case, legally, the child will get to live only with the father because, like I already told you, upon the death of the primary guardian, that is the mother, the child will automatically, the child's guardianship will transfer to the father. However, because this is an exceptional case where the father is debated to not be of to be of unfit mind, there is a case that is being pursued. So that's the concept that is involved. Thank you, councils. If we can have the next two participants.
Uh,
Um,
Ma'am,
Also, can the organizers please keep track of time because the last two times I've been keeping track of time. I've not been able to hear the bells. I'm not able to hear anything. Can
Sorry,
someone,
Judge, as you are doing it, I just thought of not disturbing you. Okay, I will do.
I
And
can't
so,
also keep track of time. So if one of you can just dedicatedly keep track of time, that would be great. Else we would run out of time.
okay, so
Um, okay, so the next case we'll have is who are the next two set of participants?
is Nikhil Kumar and Vishwa K.
uh, ma'am, just the thing. So, me and Anurag have to go again to improv for a second round. So, is it fine if we go after them?
Okay, sure. Or do you want to go up now?
I mean,
We'll go next. We'll go next.
yeah, we'll go next. It's good.
Okay, so who are the two participants now?
So according to the list, it's Vishwa K and Neetu Jain.
Okay, can you guys please switch on your audios and your videos? Who's the other participant? Okay, so we'll have Vishwa K to be the petitioner and Neetu Jain to be the respondent. So if you could please show them their case law. It's the eighth one.
Oh, eighth one.
So the petitioner in this case is the one who is initiating the proceedings, and the respondent is the person who is responding to the suit. So are you able to see the screen?
The screen is not showing. Now it is.
Yeah. Okay, can you please move to the eighth one? Yeah, so here the petitioner is the entire case law is not there. Can someone please look into it? Yeah, so the petitioner here is um, okay, the petitioner here is Madhav because he is filing the lawsuit, and the branch manager will be the respondent. Your preparation time of 3 minutes will start now.
Can you show the next half of the case?
Excuse me. Excuse me, can I leave the session? I have another competition.
Yes, I think you can leave. You have finished your part, right?
Yeah,
Yeah, you can leave.
thank you.
I've sent the cases in the WhatsApp also, so I think if you want, you can just check it out.
Excuse me, I have a doubt in the para. Whether the child of Lata is actually a boy or girl?
Um, I don't see how that's relevant, counsel, but for conversation's sake, let's assume it's a boy.
Okay, fine.
Okay. The petitioner, that is counsel representing Madhav, can you please go up? Um,
Yeah.
Organizers give them a start, and also please let them know at the 1 minute mark, 1.5 minute mark, and the 2 minute mark so that they know that they're keeping track of time. So you can start whenever you want.
Yeah. Your Honor, I am Vishwa and I represent the side of Madhav, who is a trans man actually. So, before entering into my opening statement, I would like to give a one line that irrespective of the gender, no store can be I mean, like it is the duty of the owner of the store to make everyone enter into the store and to give proper respect to them irrespective of their gender. So let me enter into the opening statement. So my client is Madhav, who is a trans man. So he entered into the store and he is into the store named H&M, and he is purchasing clothes usually, and unknowingly he entered into the trial room of men, and there is a rich lady called Lata in the case, where she is she's treating my client very badly, and she's harassing my client. The owner of the store has also pushed out my client off the store, out of the store. So I would like to say that even though my client is a trans man, he even has some kind of respect, which must be given solely to from the store. So that is not being done. So he is a consumer, and basically it should be he has to get some basic self-respect over there, irrespective of his gender. Then if he has been harassed, literally he has been harassed, and there should be some kind of proper justice to the case given, and I hope it will be given by you. Thank you.
Okay, thank you, counsel. Can we have the counsel for the respondent go up now?
Your Honor, myself Neetu, and I am the respondent for my client. So the manager who was trying to safeguard his shop, and in this condition, thought that Madhav, his regular customer, would understand the situation, and he decided to ban in order to not make the child and the mother feel inferior. And this does not definitely stand on the transphobic idea on which the lawsuit filed by Mr. Madhav stands. So it wasn't definitely transphobic. The manager was just trying to help himself and the mother and the child who were new to the shop, and just felt that Mr. Madhav was understanding, and his regular customer would understand that banning was not because of his sexuality. It was just to safeguard his shop and his financial security. Thank you, my honor.
Thank you, counsel. Now, if we can please have the cross questioning, we'll have the petitioner, counsel representing Madhav, ask the respondent a question, and then vice versa. Whenever you're ready, petitioner.
Hello, yeah, can I ask my question?
Yes, please go on.
Sorry, I hope it is a network issue. Okay, so coming to the question, my opponent told that the owner of the shop is actually financial due to some financial reasons they have sent him out, and they are saying that he's a regular customer. Just because he's a regular customer, he cannot be pulled out of the shop for the reason of his gender, because he did not harass anyone or he did not do any mistake in the place. Just he is a trans man on the respect of his gender. They have sent him out, and also one more reason is that because of the business. So how can she say that it is he's a regular customer, so he can be sent out?
Yes, counsel, can you please answer?
Well, as Mr. Madhav says, this is not because of his it's because of him being transphobic. The manager, he did not push Mr. Madhav out. He just banned Mr. Madhav because he was trying to safeguard his own shop and his financial security. And assuming that he's a regular customer, he did ban, but it turns out that he got the different idea that the manager banned Mr. Madhav because of sexuality, but no, he has no problem because Mr. Madhav is a transgender. That is all, ma'am.
Okay, thank you, counsel. So My question to the my question to the petitioner, that is the council representing Madhav, is a store, in this case, this particular store, H&M, is a private property. It's not a public property, it's a private property that belongs to a particular individual. When it's not state owned, I, as an owner of a private property, can put in place certain restrictions as to who can enter and who cannot enter. When that is the case, on what basis is your client trying to pursue this suit? Because the respondent here, the branch manager, as the owner of a private property, has the right to put in place certain restrictions as per his whims and fancies. So, can you please respond to that?
Yeah, Your Honor. My client actually felt that they are just harassing him because in the name of the rich lady Latta, they have just banned him out of the shop just because his business should not be get out. So the basic rule of the shop is to give some proper respect to the customer first and to treat them everyone equally. So that is the basic rule of the shop. But they did not do that. They did not even try to do that just because their business is going to fail now. And how can this be? So my client is just saying that they should be given some proper action. They should be taken some action against Lata and the shopkeeper.
Okay, thank you, counsel. So my question to the respondent representing the branch manager is, there is a legislation in India called the Transgender Persons Act, according to which no person belonging to the third gender can be discriminated against anywhere or denied of service on the basis of their gender. When the case facts here incline towards Madhav being discriminated because of his gender, on what grounds does the counsel for the branch manager justify his act of banning Madhav?
Well, the base on which Mr. Madhav's lawsuit stands is a bit misleading because the manager was trying to save his shop. Moreover, the new customers, they were a bit transphobic. So, imagining the situation that would have happened if the manager had not banned Mr. Madhav, and the mother and the child would be different. Because they are definitely transphobic, and that is when you can file the lawsuit saying that the manager was discriminating on the basis of his sexuality. But no, this time the manager, he was just trying to safeguard his financial security, and it is not definitely on the basis of transphobia or something. It's just to safeguard his security and to make sure that the other customers do not feel inferior. Thank you.
Thank you, counsel. Very well done, both of you. Thank you. The next two set of participants, can the organizers please
Yeah,
call
No,
them?
actually, we did not give the closing statement, right?
Oh yes, sorry. Can you guys please go ahead with your closing statements?
Yeah, shall I proceed now?
Yes, please go ahead with your closing statement.
Your Honor, as you have read, you have heard both the stories. I would like to say that in spite of right to equality, my client should be given equal right in the society and even when in the public places as well. So when he is entering into the shop, he must be treated very well and not even even though they're not treating him very well, they must have given some basic respect to him, like not banning him out of the shop. So I would like to say my client wants to file a case against the rich women Lata and the owner of the H&M shop. So I hope you will give some proper action regarding that. Thank you.
Okay.
Your Honor, so I would like to say that even if Mr. Madhav wasn't a transgender, and even if at that time the mother and the child had felt unsafe, it's the manager's decision to whether to ban Mr. Madhav or not, and it is definitely again not because of transphobia, and so I would like to plead that my client is innocent. Thank you, Your Honor.
Thank you, counsel. And counsel, for the respondent, right to equality is not applicable here. Right to equality pertains to the right to equality every citizen of India has before law, not against a private entity. Right to equality is only against the state, either government or governmental agencies or instrumentalities. So I hope that will be useful for you the next time you do lawyer up. Very well done, both of you. Thank you for participating. If we can have the next set of participants.
So the next set of participants will be K. Sam Emmanuel and Nitin Kishore.
We
Okay.
had, ma'am, very sorry. Yeah, me and
Um,
Anurag wanted to go because we had improv happening now.
okay.
Yeah. So is your
If you're
improv?
ready to go up,
Yeah,
switch on your cameras and your audios, and you
yeah.
can go up.
Um, Anurag,
Can you hear me
yeah.
and see me?
Okay. Can we have case number 10 for them, please? Anurag will represent the.
The screen sharing stopped actually.
Yeah.
He's
Yeah.
trying to figure it
Yeah.
out.
Give me
He's
a
trying
minute.
to figure it out.
Or is it
Um,
possible you can send the case in WhatsApp?
They will.
we'll have Anurag represent the. Okay, we'll have Anurag represent the field officer, and we'll have the other person who Gokul representing the child. You'll know when you see the case, but just make a note of who you're
Also,
representing.
a general question. So it will be first opening statements, then cross questioning for each other, and then you cross question us, and then closing statement. Is that right?
Yeah, that
And
sounds
how
right.
much prep time?
You have 3 minutes preparation time.
And how long can the opening statements be for?
It's 2 minutes.
Thank you.
Thank you.
So as requested by the participants, I have sent the case in WhatsApp. So
Can
will
you
you be
also
able to
screen
read it?
share?
Could you also screen share, please?
Yeah.
Question: why did was the pedestrians asking the child to move toward or near the pavement in relation to the Leicester coming through?
It's just to indicate where exactly the bicycle was placed. So it's clear that they're in the middle of a bike chase, right?
Yeah.
And the fault is not that of the child because the child isn't going anywhere in the middle of the road. The child is, traveling close to the pedestrian pavement than he is to the road. And despite that, he still suffers this particular accident.
All right. So
The
I will
frame
be
of
the
reference,
pedestrian,
the
right?
frame of reference here is that despite of the fact that it's no fault of his that he wasn't driving the middle of the road, he was only in the corner of the road, he
Yeah.
still was, he still met
Hit.
with an accident. Yeah.
All right.
What was the bell for? Others?
No, actually, as you instructed, we just did it. They still have 1 minute 45 seconds.
You can just put it in the chat box if
Okay,
that's
fine.
okay. Yeah. For the opening statements, the 1 minute mark, 1.5 minute mark, you guys can carry on. You guys can carry on. For the opening statement, the 1 minute mark, 1.5 minute mark, and the 2 minute mark. Indicate the 1 and 1.5 in the chat box. Two, you can ring a bell. Um, and for the rest of it, you can just let them know as such, but don't interrupt them when they're giving their opening and closing statements.
Yeah, so the time's up for.
Yeah, can we please have the counsel for the field counsel for the sorry the parents go up?
I'm the field officer, right?
Um, did
Yeah,
you not did you not listen when I told you?
No, I did. I just
he
reconfirmed.
was the field officer. I was the child's representative.
Okay, so that is for the parents, right?
Yeah, basically.
So the parents have initiated the suit, so they will be the petitioners, and the field officer will be the defendant. So if we can please have the petitioner counsel go up.
This one, what? Uh, 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 should I start?
Yes.
Okay, cool. So, Your Honor, we need to understand the total details of the case. So, the fact of the matter lies that Paul, who was merely an 8-year-old boy, had moved over closer to the pavement, going on a bicycle when the said injury had happened. The fact of the matter lies that Leicester has broken multiple different civilian laws, such as going in the wrong direction in one-way roads and going on pavements where walking is supposed to happen, and that has resulted in the injury of the child. The fact of the matter lies that despite all that they can claim that they were chasing terrorists who cause public harm, they themselves have carried out public harm, which is pretty counterproductive to the point of going against and catching someone who causes public harm. And the fact of the matter lies that this act counts as a private nuisance. So the thing that we need to understand here is that when he was on the public road trying to enjoy the usage of his cycle, he was unfairly injured, right? And this sort of act must be not just met with monetary compensation for all the full hospital fees of the said boy in question, but also should result in an apprehension of Lester, the field officer who has caused the injury, because of the fact that despite legal frameworks being set in place to prevent such accidents, they had in fact caused public harm to the boy in question. How much time do I have left? Is there
I
time?
have nearly 30 seconds left. Sharp.
Yeah, and
Can you please put it in the chat box also instead
yeah,
of
can
just
I?
the bell? Please
Yeah,
go on,
can,
counsel.
yeah.
Please go on.
Okay, and the second thing that we need to understand is the fact that the narcotics team did not make the citizens aware that that particular chase or that particular operation was being carried out in that region. Because if that were the case, the boy wouldn't have been on the road near the pavement itself. So before carrying out an operation to or such as the pursuit of a said terrorist responsible, there must be sufficient information being given to the people of the region so that appropriate measure. Can I finish with the sentence?
Yes, yes, please
Yeah,
finish.
appropriate measures can be taken, which also had not occurred. Thereby, it is the field officer and the rest of his team which is clearly responsible in the said case.
Okay, thank you, counsel. And when the respective counsels are talking, please keep track of how many bells you've heard. The first one is the 1 minute mark, second one, the 1.5 minute mark, third one is your final one. Please keep track as in when you're talking. So if you can please have the defendant counsel go on.
Yes, Your Honor. So first of all, I would like to say that my client is not in the wrong, since there is clearly rules specified in the Police Act that there should be sirens when the police are on a hot pursuit or a hot chase. So clearly, this means that the police are allowed to evade one ways, allowed to evade traffic rules as long as they are in a pursuit. And to indicate this pursuit so that public harm is not caused, all they need to do is put on a siren, which my client has clearly done. That's my first point. The second point is that there's been a complete misunderstanding of the situation here, which is that the pedestrians, after hearing the police sirens, have told the boy to move. In this the boy got confused, and when he's trying to move in, the police officer who was riding fast to nab the terrorist has seen this boy and tried to react and go sideways so that he won't hit the boy who's driving in the middle of the road. But the communication was too late, and the boy and the police officer went in the same direction and collided on the pavement. This is what I can easily interpret from this case. Another point that I would like to make is that opposition counsel said that there's more public harm caused than what is trying to be prevented.
I would like to say that this statement is contradictory, since if this public harm of the terrorists was not tried to be stopped, there would now be more bombs and drug deals coming in, which would obviously cause even more harm than how it already is. So I would like to say that accidents always happen in police cases, and for the greater good, my client needs to be pardoned. And my client also did not do this in a wanted manner. He only tried to carry out his duty, and while carrying out this duty, he has met a fatal accident. Uh, so hence, I would like to finish off by saying that my client was not in the wrong, and he was only carrying out his duty, and he's carrying it out appropriately by using the sirens and all the laws that is possible for him to use while on a police chase for nabbing all these dangerous criminals. With that, I would like to conclude, Your Honor.
Thank you, counsel. Now, if we can please have the petitioner ask the defendant counsel a question and vice versa.
Wait, I should ask him first, or should?
Yeah, you're the petitioner counsel, so you will ask him a question.
Wait, is it just like a question, or do I have like a set period of time where I can ask how many ever questions I want?
No follow-ups, just ask him one question.
Okay, so very simple, right? You had stated that if the sirens were on, they could evade the traffic rules. But considering that if the sirens were on the road where there are cars which can react at appropriate speeds to the speed at which the bike is going, that would make sense. But considering that this is a bicycle and a mere guy, where the region of transport where the officer is going is a pavement where people even of old and young age walk who can't react appropriately to such to a bike moving at such a high speed can come in. Considering that particular case, do you think that going on a pavement still gives still gives the Lester, the field officer, the right to exercise and evade the traffic rules? And second, considering the said point quoted that they can't react to this, how do you think that the child should have approached?
Petitioner counsel, please ask one question. What's your question?
Yeah. How do you think that an 8-year-old child who was riding a bicycle, who could not react, who could possibly can't react to a vehicle coming at such high speeds accelerating towards him, how do you think the child should have reacted when it was in fact the fault of Lester going in a pavement where a reaction itself wasn't possible to the vehicle moving at such a high speed?
Yes.
Chairperson, do I get any time or should I reply now itself?
You have to reply right now. Yes.
Yes, Chairperson. Sorry. Yes, Your Honor. So, Your Honor, I would like to reply to his question by first of all stating that the police and ambulance and fire department are the only three vehicles which are allowed to evade traffic rules because they are fighting for cases of emergency. Especially police, they are trying to nab a terrorist here. So we have a case of emergency. This is my first point. Hence, they are allowed to break traffic rules and go in a one-way. This is my first point. Second point is that there is a fundamental problem with people of India, which is that they walk in the middle of the road when pavements are clearly laid down for them. Where do they expect the vehicles to go if they walk in the middle of the road? So the pedestrians are walking in the middle of the road. There's a bicycle, small kid going in the middle of the road. So if the pedestrians are persuading the person to go to the side suddenly, then how do they expect the police officer to know that and react to it? The police officer seeing the pedestrians in the middle decide to go on the side, and if the cycle comes at the same time in the side, what can the police officer do? That is my second point.
Just a clarification, Your Honor.
Yes.
Given the case, the pedestrians were not on the middle of the road, right? I mean,
so any logical fallacy that you think has been discovered in your opponent's speech or rebuttal, please include that in your closing statement.
okay.
I already instructed in the beginning of the event that if you try to incorporate any logical fallacy that your counsel might have uttered into your closing statement, that would get you brownie points. So if at all you have any, please incorporate it into your closing statement.
Also, could this one repeat the name of the act alone that they had mentioned? I did not get the name of the act.
Is time up for my statement or?
Just give him the name of the act.
Police Act. Indian Police Act.
Sorry?
Indian Police Act.
Now, can we please have, are we done with the cross questioning? Or
He has to ask me.
Okay, the defendant counsel, please ask a question and make it concise, make it quick.
Yes. So when there's clearly rules specified that ambulances and police are allowed to break traffic laws in the case of emergency, why is it that your client has filed a case for my client simply carrying out his duty in the name of law? And even when sirens or other such warning signs have clearly been produced.
Okay, can I go ahead and answer?
Yes, counsel, please
Okay,
answer.
so it's very simple. In the road, if it was going on a wrong way with sirens, that is a completely different issue. The fact of the matter lies that Mr. Lester was on a pavement where people walk, where there are slower vehicle, where by the side of which, like cycles, case in point, there are slower vehicles and people who walk. That time when it is of extreme evidence to Mr. Lester, who was on the bike, why would he go on high speeds on a pavement when he could have exercised the right and gone on a road instead, where there were cars which could have avoided an accident due to them reacting at higher speeds as well? Why did Mr. Lester go on a pavement where there were near people walking who couldn't possibly move from a route of a bike coming at such a high pace? Is the question.
Thank you. Thank you, counsel. So my question to the petitioner counsel is, there is such a thing, that as when a public servant is in the middle of the exercise of his duty, such as right here where it's a car chase, the discharge of duty by public servant is outlined in our legislative framework as an exception. That is, if during the discharge of their duty as a public servant, they happen to cause injury to any party, they can be absolved depending on the circumstance of liability. So, keeping this legislation in mind, can the petitioner counsel please elaborate as to whose liability they think this particular act is, whether it's the field officer and his colleagues' liability, or if the petitioner believes that any other party is also capable of being liable in this case?
No, the liability lies on the field officer per se. The fact of the matter lies here is what the petitioner would like to state, that cycles can still go on the road. Walking on the main road is wrong. Now, considering that the cycle was asked to slow down, given in light of the events on the main road, and it was going close by to the pavement, not on the pavement where it is strictly confined to walking, and that Mr. Lester went on the pavement and then swerved onto the bicycle, which was basically near the pavement. Not only has there been a change in trajectory because the bike has hit the child coming from the pavement to a place in the road near the pavement where the bicycle was going slowly, there has also been an infringement wherein in pavements where there was no other vehicle, no other similar sort of condition that was there, like the bike that was going on the high speed, has gone on the pavement and thereby has also inalienably put everyone at the pavement at risk, which is not something that any other party has done. The child was well within his legal rights, but the field officer has not only crossed that but has also made actions that not just don't make logical or ethical sense either. So the liability lies upon the officer per se.
Okay, thank you, counsel. So my question to the defendant counsel is, keeping in mind the exception that the Indian legislative framework provides, the defense rather, that the Indian legislative framework provides to public servants, there is a catch. In other words, there is an exception to this. That is, if a public servant acts with utter indifference or a conscious disregard for the safety of the others or the safety of the public involved, he or she can be held liable. Keeping in mind this particular legislation and the exception to it, and taking into close consideration the facts of the case and how much harm has been caused by the act of Field Officer Lester and his colleagues, can you now justify as to why he should be absolved of liability? when it is clear from the circumstances and the case that there has been a conscious disregard for the safety of the other public involved.
Okay, thank you, Your Honor, for that question. I would like to reply to that question by stating that first of all, there were people, pedestrians, as well as other vehicles, possibly in the middle of the road, which is why, just so that to avoid disturbances during this chase, and so that public who are walking literally in the middle of the road can be safe, the police officer who has possibly seen that the pavement was free rode on it. However, like I said in my previous argument, there was a miscommunication due to which the bike had hit the bicycle. That is my first point. Second point is that my client has not disregarded his duty of being harmful to the public, because uh, even though he has caused injury to this boy, he has only done it so that there won't be greater harm to the public from terrorist bombing or selling drugs in the country. He has only tried to stop the terrorists, and because of that, tried not to disregard his duty, and because of that alone has this happened. Like I stated earlier, it's a clear sense of accident, and it is not a fault of either of the parties involved. So, if in the end, even if liability was to be given to somebody, it is definitely not on my client. This is what I would like to say and conclude here.
Okay, thank you, Counsel. Now,
Ma'am,
if you can please.
just a clarification. Nowhere in the given details does it say that public were on the middle of the road, and it by nature is assumed that the public go only on the pavements. Considering that there
No,
was
Counsel, no, Counsel. Usually, when a given fact is not given, if it's a reasonable assumption to make, the judges may accept it. So, in this case, I believe that whatever fact has been added on to the case facts is a reasonable assumption to make.
so
So, we'll
questioning
be
can be differ to the assumption, or can we say why what they assume isn't right?
so if you can address all of that in your closing statement, starting now.
Okay, so first off, here is one thing that we need to note. Obviously, there weren't pedestrians in the middle of the road, considering that this act was only accident that occurred. And second, if the pedestrians themselves were in the middle of the road, they wouldn't ask a child who is riding a bicycle to move to somewhere near the pavement for his own safety. Second of the if they were themselves in the middle of the road, because it's completely illogical. Second point that we need to understand, that basically the field officer Lester acted with clear indifference. The fact of the matter lies that there was no set trajectory that the officer followed. He moved from the pavement to a place near the pavement, and the fact of the matter still lies that the pavement constituted only a place where people could walk. So the officer, instead of going in the main road where there were cars, used the pavement, which is a clear act of indifference, which was completely illogical. And the second way that we need to understand is that this caused private nuisance, because the property of the child, which was the cycle in itself, was being enjoyed in all with all the rights given to him by the constitution, however was hindered upon and has caused him harm in this said case. And that clearly is a private nuisance crime, which has to be addressed either with monetary compensation, and then this one not with lesser or with lesser being apprehended for his said actions.
Okay, thank you, Counsel. If we can please have the defendant counsel give their closing statement.
Thank you, Your Honor. There has not been any mention that there were people on the pavement, nor has there been any mention that there were people not necessarily in the middle of the road. Middle of the road doesn't mean they have to walk exactly in the middle. They could also be crossing. They could also be, gazing off or something, anything like that. So what I basically mean is, especially if you have an 8-year-old kid next to you, anybody would tell him to go to the side, and that doesn't necessarily mean that that people people are not telling him to go, continue in the middle of the road, because clearly the boy was told to go to the side of the road, since he was small of age and he could not clearly, as seen in the circumstance, handle any accident coming from the middle of the road. That is my first point. So only for his safety was the pedestrians who were in the middle of the road telling the kid to go in the side. That's my first point. Second point is that the like mentioned in the Indian legal framework, the police officer, India, the servant of India, simply carrying out his duties. So he clearly has seen that the pavement was free and it was the middle of the road which was crowded. And that was why my client decided to take the decision to continue his quick and fast chase that could go out of hand anytime, which would cause greater harm to the population of India. That was the only reason why my client decided to take this route. In the other case, he would not do that. Hence, I would like to conclude by saying that my client has clearly not been in the wrong, and it is clearly a circumstance of accident, and he should not be apprehended in any manner for this. Or
Thank,
maximum, he must be given a very small fine.
thank you, counsel. And if you can, I have a question for. You're done with your round. I just have a question for the petitioner counsel. Petitioner counsel, can you please define private nuisance for me?
I mean, private nuisance, the way I read up before, so my senior said go through a set of stuff, so I did that. The way I read it, there was two things, private and public nuisance, if I'm not wrong. So if I'm not wrong, public nuisance occurs when it is this one, what, too many people in the public, but private nuisance is when a particular enjoyment of one person's property is hindered and damage is caused. Now, I mean, I'm not completely sure if this is the application, but the way I applied it was the property that kid was enjoying
So,
was his cycle. Oh yeah,
petitioner
very slow.
counsel, when we talk about the concept of private nuisance, it comes under civil wrong. It's tortious. What we're dealing with here, is more inclined towards a criminal wrong, first of all. And second of all, you only bring up a private one of the three integral elements in order to establish private nuisance is the existence of an actual land. Property here does not include movable property. In a private nuisance, property is confined to an immovable property, which is a land, a piece of land. And the second thing is the owner. If I own a piece of land, the three essential things I need for a private nuisance is I need the land, and then someone should have obstructed my enjoyment of this land, and three, that obstruction should be unreasonable. So do you now think whatever has taken place in this particular case is a private nuisance?
No, given of what you said, my understanding was wrong of that.
Okay, and defendant counsel, what was the act, what was the legislation you mentioned multiple times?
Indian Police Act.
Okay, do you know who a field officer is? Who do you think is a field officer? Define field officer for me, please.
He's a traffic policeman who takes care of. I don't know. Field officer. Sorry. He's a person who takes care of things like terrorism or drug deals or like stopping that, basically.
Okay, do field officers, does the word field officer usually, do the police come under the purview of it?
I mean, in countries like the United States, the CIA are also constituted under the police.
So, a field officer is usually a term, an umbrella term, that we use for the Air Force, the Army, the Navy, etc. So, we usually don't relate the term field officer with policemen, and the usage of the Indian Police Act wasn't entirely. Do you think it was appropriate in this case?
Not fully, yes.
Not entirely, yes. And word of advice, if you don't entirely know the legality of it, scrap it. We are only looking for logical arguments. If your arguments are logic, the legality is not going to get you any extra points. At least that's not how I work. If it's logical, well and good. And I don't think they expect anything more from school students, but very well done. Very well done. So, yes, you guys had to leave, right?
Yes.
Yeah, just
they're
one
calling us,
question.
Yeah.
So, will a public nuisance be, or is that part also not applicable here? Because when I read about it, it said there was a special part for only a single person being harmed, especially out of the public. So, would that?
Yeah, so a private usually private refers to one person, like an independent entity, right? But private nuisance as such is only can only be invoked when there is a property, like a land, and when someone basically obstructs my enjoyment of a particular piece of land that I own, and it's illegal and they don't have the right to do so, that's when it's a private nuisance. For example, if my neighbor grows a tree and the tree's branches come into my property and they're obstructing me from growing a tree, that becomes a private nuisance. You understand?
Okay, cool.
Yeah,
Yeah.
public nuisance comes under the Indian Penal Code, which
Excuse
is
me,
more
sorry to
inclined again
interrupt, Judge.
towards a criminal wrong than a civil wrong. I think we've exceeded time a lot. Can we please
Yeah,
have
yes.
the next two set of
Thank you.
participants? Yes, yes, thank you.
So now, actually, now I think Sam Emmanuel can go for a spin ion. I think because he has this competition. You better finish that and come. Okay, Sam, will
Yeah,
it?
yeah, okay, fine.
Yeah, you finish it and come. So, and I think I will be stopping my presentation so that Sujit will continue. So the next set of participants will be um, Pujita Shreyal Anuraj and Manan S. Parekh. So was I audible? Are you people there?
Yeah, 1 second.
Yeah, yeah, okay.
Okay, yeah, you can see me, right? Yo, I'm visible, right?
Yes, you are.
Oh, okay, all right, cool.
Who are the two participants?
It's Shreyal and Manan Parekh.
Okay, so we'll have Shreyal be. Is it Cheryl or can you please pronounce your name for us so that we don't
I'm
keep
so
getting it
sorry
wrong?
to interrupt. It's Cheryl, yeah.
Oh,
Cheryl, okay.
sorry.
We'll have Cheryl be the
Cheryl.
petitioner
It's
and
okay.
we'll have Manan be the respondent. Can we please have case 11 for them? Yeah, so the petitioner here is the one who files the suit, so Charan. Cheryl will be Charan's counsel, and the respondent here is Geeta, so Manan will be Geeta's counsel. Are we clear? So
Right, yeah.
you have 3 minutes preparation time and starts now.
Yeah, so the time is up. Sorry, people. Actually, I muted my mic and I was ringing the bell. Very sorry for that.
That's all right. If we can please have the
I actually have a doubt. I was just
yes.
about to ask it. The thing is, your the will plays a very important role, right? So, what did the will say?
So in cases where the facts aren't explicitly given, you are also marked based on how well you assume the presence of certain facts and certain circumstances, as long as they're reasonable. In this case, we're going to assume that it's intestate, that is, there is no will. So, for the sake of this particular case, we're just going to assume that it is intestate, that is, there is no will. So,
Okay,
keeping this
all
in
right.
mind, considering the time is over, can we please have counsel for the petitioner going up?
Yes, Your Honor. Am I audible?
Yes, please go on.
Your Honor, I would firstly like to state the facts of the case. My client, Shardin, is a class 1 legal heir and he has the right to inherit his father's property. But Geeta, the opposite counsel's client, is refusing his advances on gaining his father's property, which he has a legal right to. Geeta is refusing his advances and taking law into her own hands, which is a clear disrespect, and she is denying my client of his basic privilege and right to inherit his own father's property. And since there is no will here, Geeta has no rights to do that just out of a claim that Sharon has never visited his parents, because this has no role to play. I'm sorry, someone want to say something? I heard somebody's voice.
No, no, no counsel. You can go on.
Okay, yeah, cool. Thank you.
Do you want to? Okay, add 20 seconds extra time. I think she's having a bit of an internet issue.
Yeah, yes, that's why I didn't interrupt actually.
Yeah, she's having a little bit of an internet issue. Is she
And
stuck for me or is she stuck for all of you?
Even for us.
can I
Yeah,
continue?
it's
Yeah.
Um, you're lagging a little, so can you please rewind your speech and begin again, if that's fine? Cheryl, can you please
Hi.
figure out your
Yeah,
internet
am I audible?
situation? Yeah, but I
Yeah, yeah,
think
yeah. I'm
you're
very
lagging a lot, so can you
sorry.
please figure out your internet situation?
Yeah, sure. Just give me a second.
Okay. Can we just have the respondent council go up in the meanwhile? We'll let Cheryl figure out her internet situation.
Yeah. All right.
Is it all
Again,
right
again,
now?
how many minutes are the speeches?
So you have 2 minutes for your opening
2 minutes.
statement.
All right. Oh yeah. Yeah.
Okay, just wait for a second. Cheryl, is your internet situation figured out? Is it fine
Yeah, yeah,
now?
yeah. Is it all right
So
now? Yeah, yeah.
we'll just
It
have
is.
you go on. Please, you have 2 minutes. Quickly finish it up for your opening statement. So please start whenever you're ready.
Yes, Your Honor. Thank you, Your Honor, and I'm very sorry for all the inconvenience caused. What I would like to say is that Sharin, my client, is a class 1 legal heir to his father's property, and the opposite counsel's client, Ms. Geeta, is taking law into her own hands by denying my client's privilege, that is, the right to inherit his own father's property, with a baseless claim that he has not even visited them once in the past 15 years. She is trying to overrule the legal system, which clearly states that a son has the right to his father's property with this claim, and this cannot be allowed, Your Honor. And my client Sharon deserves a share of his father's property, and I hope that you will consider this case and do justice to my client.
Are you done?
Yes, Your Honor.
Okay. Thank you, petitioner counsel, respondent counsel. you have 2 minutes for your opening statement. Please start whenever you're ready.
Yeah, three, two, one, go. Panel, actually, the proposing counsel or the plaintiff today had twisted the facts a little bit. I mean, yeah, the facts were right, but they were presented in front of you in a wrong manner. I would like to stress upon one important fact, which was that Charan hadn't returned to home since the past 15 years, which essentially means that all the assets that now belong to the property, all the property that is now under the ownership of this family was without him, and as a result, he does not have any right to claim over it. Why? Because from the past 15 years, all he has done he has not affiliated with himself with the family. So first argument of ours is that there was no affiliation, and as a result there's no basis to claim whatsoever. Secondly, it is, I know, panel, that a law has no space for morals, but here we need to take into consideration in front of the court of law that Geeta had taken care of the father and had gone through a lot of expenses, and it should be made sure that she gets some kind of a remuneration, and that is why it is rightful when she claims in front of the law that she deserves the highest part of the property, the entire property for that matter. And that is why we believe that the defense is not liable for the claims that are made by the plaintiff.
Okay. Um, thank
Oh,
you.
I have some time left.
Oh, okay. Yeah, go on, go on.
Oh, I
I
do have
think,
some time left, right?
yeah,
No,
you'll
okay, yeah.
be, it'll be indicated at the 2 minute mark that your time is over. So until
Okay,
then, you have the
yeah.
floor.
Yeah, okay. So continuing, panel, they never actually gave you a legal claim as to why they never gave you a legal claim, and that is why this all entire arguments of theirs should not be taken into consideration, because simply we at least tell you that on our side we say that all the ownership of the assets that belong to this particular family is now was actually earned in these 15 years, and that is why Charan does not deserve them, because he never contributed anything towards it and he did not affiliate himself. So there's no obligation whatsoever. And with this, we believe that we have proved our burden, while the plaintiff has failed to do so.
Okay. Thank you, counsel. So now we'll move on to the cross questioning. So petitioner counsel will ask the respondent counsel a question and vice versa. So whenever you're ready, petitioner counsel.
Yes, Your Honor. Counsel, you stated that the law has no space for morals, but Geeta needs remuneration or compensation for all her expenses, right? So, do you think that you can override the law just because somebody has fulfilled an obligation of taking care of their parents out of their own free will?
Yeah, thank you for your question. First of all, and yes, as I stated before, I know that the law doesn't have a place for morals, but all I'm trying to do is to present in front of the judge that there is a moral reason. Also, it's just a perspective to our side of the case, and it should not be considered as a legal claim, because we do not plea that as our legal basis for any of our claims. Just painting a picture.
Thank you, responding counsel. Now you would be asking the petitioner counsel a question whenever you're ready.
Yeah. Okay. So doesn't the plaintiff believe that since those 15 years, it was actually Charan's responsibility to contribute to whatever amount of property that was owned by this particular by the family? I mean, it was his responsibility to do it, and he did fail. Yes or no?
Your counsel, a clarification. I have no clue what you mean by contribute to the property earned. It's the
Contribute
parents'
as in
property.
Cross
How do you?
questioning. No follow ups, please. Counsel for the respondent. Please answer petitioner counsel.
Okay, Your Honor.
Are you clear
Yes,
with the question?
yeah, sure. I'll just go ahead.
Okay, yes, please go ahead.
Yeah. Your Honor, I do not understand what the council means by contribute to the property earned. It's the parents' property. You can't earn property for your parents. When you earn property or contribute to the property earned, it becomes your property. It's the parents' property, and this has nothing to do with the 15 years because the opposite council has stated multiple times that all property earned or contributed within these past 15 years, and that's a very subjective statement, and the facts of the case are not enough to substantiate that statement. So I think the opposing counsel's question is invalid in itself because you can't contribute to a property. There is no contributing to a property that somebody else owns.
Thank you, counsel. So my question to the petitioner counsel is, counsel, under the Criminal Procedural Code, the CRPC of the Indian legislation, Section 125 states that states about parental maintenance. That is, a child has a legal obligation to provide their parents with maintenance if they do not by themselves have the means to support themselves. So the council in their speech, in one of their statements, mentioned that just because your client has not in any way been associated with this family doesn't mean he can be deprived of said assets. But considering the legislation which states that your client as a child clearly has a legal obligation to provide his parent, one last living parent, with maintenance, on what basis do you think he cannot be denied a share in the property?
Yes, Your Honor. As you stated, it's been mentioned in the law that the child has a legal obligation only if they have no means to support themselves. There was clearly another person that could support the parents. So my client did not abandon his parents, and he would have definitely been there if he was the only person with the entire responsibility. But since there was somebody else to take care of his parents, and a clash of opinions or a continuous clash of opinions will only do more harm than good, I think my client is in the right here and has no culpability.
Thank you, petitioner counsel. So my question to the respondent counsel is, interstate rules as per the succession acts that exists state that it is immaterial. The circumstances or relationship fractures between a family are immaterial when it comes to the allocation of assets. This being the case, and your whole contention is that this is an exception to that, the fact that the circumstances here are an exception to the law. Can you please justify further as to how far you think your contention holds good against the law? That is, the law states that irrespective of any relationship fracture, the child of the child is entitled to, if there is no will, a child is entitled to a certain set of assets. And this is the case, how do you argue your case is an exception to the legislation?
Yes. So thank you for that question. Well, panel. Actually, this case is definitely an exception, and the court also has the power to interpret this particular law. And now, what I would like to plead is that when we consider the law, that the whole aspect of the treatment that is given by the child is immaterial towards the succession. We believe that over here, particularly, it is not, because for 15 years the child did not fulfill his responsibility, and as the plaintiff wrongfully puts it, that he never actually did something wrong to the parents. Well, there was a conflict of interest, and that is why he left the house. So it is definitely not something good that happened, and that's why he left the house. And that is why it was actually true that he was not fulfilling his obligations, and that is why our case stands.
Okay, thank you, respondent counsel. Petitioner counsel, you mentioned that your round is over, but petitioner counsel, you mentioned that the son here is a class 1 heir. Under what legislation do you think he qualifies as a class 1 heir?
Hindu succession laws, if I'm not wrong.
Yeah, the Hindu Succession Act. Yes, thank you, both of you. Very well done. If we can have the next set of participants.
Your
Thank
Honor,
you.
closing statements.
Oh, I'm
Oh
so
yeah.
sorry. Please go with your closing statements.
So
Yes, Your Honor. Thank you so
The
much. Should
the
we
respondent
proceed
will
first?
go first for the closing statement,
Yeah, I'm
followed by
sorry.
the petitioner.
yeah, right. Yes. So three, two, one, go. Panel today, the arguments that were presented by the plaintiffs do not hold water because of a lot of reasons that are already pointed out. Because the first and the foremost thing being that the obligation itself of the son was not fulfilled, and secondly, he had again not contributed anything towards the household, and as a part of the Hindu Succession Act itself, it is required for this for it is required for heir to be eligible to be the karta of the Hindu business itself, which is essentially can be taken as as the household over here, and as a result, he does not deserve any property whatsoever, and that is why our claims stand true, and that's why we need to win this case. Thank you.
Okay, thank you, Counselor. Petitioner Counsel, if you can please go on with your closing statement.
Yes, Your Honor. Your Honor, my client deserves property, a share of the property of his father, because as I've already stated, he is a class 1 legal heir and he has not failed or flouted any of his legal obligations because he did not abandon his parents. They have means to support them. And another point I would like to make sure, Your Honor, the opposing counsel stated that since Geeta has faced a lot of expenses, she needs remuneration. And I would like to state here that legally there should be equal distribution of the property that is to be inherited. And our client or me, we aren't stating that all the property should only be inherited by my client Sharon. We are only stating that it should be equally distributed amongst all of the legal heirs. And yes, Your Honor, thus Geeta is taking law into her own hands, and this should not be permitted in the court.
Thank you, Counsel. I think that concludes it. Can we please have the next two set of participants?
Yes, sir. So the next participants will be Nikhil Kumar and
How many more participants do we have?
actually it's one, two, three, four, seven.
We have 7 more participants.
Yeah,
All right.
so three more cases and one will be odd.
Okay. So can we please have number 14 for these two? Yeah. If you can please present case number 14.
Yeah, so the participants will be Nikhil Kumar and K. Sam Emmanuel.
So we'll have who? Nikhil Kumar and who?
K.
Me, ma'am.
Sam Emmanuel.
Okay. So we'll have Nikhil Kumar be the petitioner, that is the Christian family, and we'll have Sam Emmanuel be the respondent, that is the mosque in question. Your preparation time of 3 minutes starts now. Is that the 3 minute mark?
No, that's a 2 minute one.
Okay.
People still have 1 minute more.
Okay, I think that concludes your
Yes.
preparation time. So, if we can please have the counsel for the petitioner, that is Nikhil, and I'm assuming, yeah. If we can please have the counsel for the petitioner going up. You have 2 minutes for your opening statement starting now.
Yes, ma'am. It is a Muslim dominated locality. That doesn't mean that only Muslims can live there. Many people can also live there. That is not stated that only Muslims can live in that locality. So, playing prayers very loudly may disturb another people of the another religion. So it is not acceptable to play loud prayers in that locality. Only uh, only Muslims are not in that locality. A Christian family is all there. Maybe an Hindu family can be also can be there. So that doesn't mean that they can put a play louder prayers and they can just play it without uh, any so they need to see that they are not only Muslims, they are also people who belong to another religion. That's all, Your Honor.
Thank you, petitioner counsel. Respondent counsel representing the mosque. If we can please have you go on.
Yes,
Two
Your Honor.
minutes for your opening statement. Please start
Yes,
now.
Your Honor. I would just like to highlight a few points of this case. So, the area which we are talking about is a Muslim dominated locality, and the speakers were being put inside the mosque. So, it was not like the speakers were being put on the road or outside some house or something. So, the speakers were being put inside the mosque. And the other thing we have to see is that it is a Muslim dominated locality. So, there are a lot of people who were not able to come to the mosque regularly every day. So this by putting the prayers in the speakers, this could probably benefit them. And this will benefit them. A Christian family and another thing is that the Christian family, they have filed a case against the mosque. So the Christian family which is living there, it is kind of a minority because this is a Muslim dominated area. So I don't think it is something which is wrong to put the speakers inside the mosque and play some prayers which would obviously benefit other Muslims in that locality as well.
Thank you, respondent counsel. Now we'll have the petitioner pose a question to the respondent counsel and vice versa. So, petitioner counsel, whenever you're ready, please pose your question.
Yes, Your Honor. Yes, the prayers were played in the mosque, but it was played that loud in such a way that it heard all over the area. So that means the prayers, the loud prayers can disturb another people too.
Okay, so
No follow-up questions, respondent counsel. Petitioner counsel, do you have a... Oh, I'm sorry. Please go on. I'm sorry, I got confused. Respondent counsel, please answer.
Okay, so answering the question which was put by the petitioner, yes, the speakers were placed inside the mosque, uh, and it was placed inside the mosque, and the mosque was at the center of the locality. So the only intention to play the prayers was that the people who are not able to come to the mosque, they could also listen to the prayers and benefit from that. But since the mosque was present at the center of the locality, such a it was it was kind of loud for the other Christian families. But said the fact that this is a Muslim dominated locality, and the other Christians are minorities in that area, I think it is totally fine to play some prayers on there.
Thank you, respondent counsel. Now, if you could please pose your question to the petitioner counsel. You're on mute.
Yes, ma'am. Since the mosque is at the center of the locality and there is no other go for the other Muslims living in that area to hear the prayers without coming to the mosque, I think it is completely pointless to argue that there is a noise pollution because the mosque is located in the center of the locality, and it is a Muslim dominated area.
Respondent counsel, what is your question?
Yes, ma'am. My question is that how can we say that it is a public nuisance because the mosque itself is in the center of the locality and it is a Muslim dominated area.
Thank you. Petitioner counsel, please respond.
Yes, ma'am. Yeah, it is a Muslim dominant locality, but that doesn't mean that any other people of any other religion cannot live there. Christians can also live there. Maybe Hindus can also live there. Majority of people doesn't decide that the locality belongs to them or to them. Yes, it is a noise pollution because they were playing prayers very loud. It, playing loud means that it is a noise pollution, and many Christian families are also there. Many Muslims are in majority. Muslims are in majority, but doesn't mean that they can do what they want to do.
Okay, thank you, petitioner counsel. My question to the petitioner counsel is, petitioner counsel, there is such a thing as Article 25 in our constitution. We've read about it since 8th standard in social studies. Basically, it's freedom to choose a religion of your own. And in this case, a religion has the right to profess its teachings, which is what the mosque is doing. When it is guaranteed by the constitution that a religion can profess its teachings, how do you think this particular case is a case of public nuisance?
Yes, ma'am. It is. They are. They are teaching their teachings, but that doesn't mean they can play loud prayers because they are not only there. Many Christians or maybe many Hindus can be also there. Majority of people doesn't decide that this locality belongs to the Muslims, or if it is no, ma'am, it doesn't belong to Muslims if they are in majority. It is totally public nuisance and noise pollution, ma'am.
Okay, thank you, petitioner counsel. Respondent counsel. So, as the petitioner counsel has multiple times stated, the Christian family has no relation to whatever teachings the mosque's loudspeaker has to say. When that is the case, isn't subjecting them to something that is forceful and against their will violative of our constitution?
Yes, Your Honor. So I would like to highlight something which was there in the case file, which is that it was stated that it is a public nuisance. Well, most of the people living in that area, they are Muslims, and the minorities are the other religions. So I well couldn't comprehend how this could be a public nuisance because majority of the people are Muslims there, and The fact that the speakers were placed inside the mosque, it was placed inside the mosque, and the fact that the mosque was in the center of the locality, and the prayers were being played. So I don't think it is something which is wrong.
Thank you. Now, if you can please have the petitioner counsel go on with their closing statement.
Yes, Your Honor. Yeah, it is in the middle of the city. Yeah, the prayers are being played in the mosque, but that doesn't mean they can make they can play loud prayers that the whole area can hear it. That doesn't mean that they can play the prayers, uh, the prayers and disturb the other people of other religions. Christians are also living there, ma'am. Majority of them are Muslims only, but Christians are also there. They may find it offensive, or they may find it disturbing, or they may find it uh, not. It is not acceptable to play loud prayers of only Muslims, because they are also Christian people also.
Okay, thank you, counsel. Respondent counsel, please go on with your closing
Yeah,
statement.
I would just like to highlight a few words which were mentioned by the prosecution. He said that this could disturb the people. Well, I don't quite understand it, because majority of the people in that area, and they are Muslims, and the sound prayer is played so that most of the people can hear that. And secondly, as I have mentioned multiple times, this mosque is present in the center of the locality, and the speakers were placed inside the mosque. So I don't think it is something which is I don't think, and it be the fact that being it is a Muslim dominated locality, I don't think it is something which is wrong to play prayers, and I don't think that could probably create a public nuisance, because majority of the people there are Muslims. Thank you, Your Honor.
Thank you, respondent counsel. I think that concludes this round. Can we please have the next two set of participants?
Yes, so the next set of participants will be Nitin Kishore and Aarti Ramya.
Um, okay, we'll have. Can we go to case number 13? So, Nitin will be the counsel for Suresh, and who's the other one? Ramya. Ramya will be the counsel for Raj. So, petitioner is Nitin, respondent is Ramya. This I hope this is clear. You have 3 minutes preparation time starting now. I think that indicates your time is up. Can we please have the counsel for the petitioner go up? You will have 2 minutes for your opening
One second.
statement.
One second. Can I set my timer for myself to just like keep a track on? Give me 1 second. Oh, yes. I'll begin in three, two, one, go. Panel, Your Honor, the facts of the simple case are here that Raj was a tenant of my client, which is Suresh, and Suresh had given him a 3 month period way prior in advance on the date he was supposed to vacate, right? But however, despite the advance and despite the 3 month information, Ramya refuses to vacate, which simply means that like she's basically violating the duty that she has to do here. So that is the reason why my client is coming in front of the case today to ensure that Ramya is vacated from the house. So what's the basic claim of this argument, right? Firstly, the basic idea of this case is that Ramya has a duty to vacate the flat. Why is this? A couple of reasons. Firstly, recognize when like the agreement of the basis is probably a rental agreement, right? That's a very valid assumption to make because you don't when someone's on a lease, you can't just ask them to vacate. And when it's a rental agreement and you have prior notice, given, you're supposed to vacate that. But secondly, notice it was a 3 month advanced time period, right? Because this information wasn't really given on the particular D day and asked them to vacate immediately. That would be unfair even on Suresh. That's why Suresh was very understanding acknowledgement of the fact, and therefore had given Ramya a 3 month time period advance. Therefore, whatever reason that they say invalidity of facts or unavailability of new facts for various reasons simply isn't valid because it's 3 month time period to meet those requirements when a person simply shifts a flat. Because these agreements have no like these have no legal basis. But thirdly, notice crucially how this recognized like the reason why probably the Suresh asked Ramya to vacate is probably for one of two reasons. Firstly, that it could be that Ramya probably wasn't a good tenant, or Suresh probably wanted to use the flat for something. Regardless of whatever the reason between these two cases, Suresh has a legal basis and Suresh is entitled to ask Ramya to leave because it's own private property and not Ramya's. Therefore, he has a right over it and right over who uses the property, who he can rent out to, and what he can do with it. Thank you, Your Honor.
Thank you, petitioner counsel. Respondent counsel, you have 2 minutes for your opening statement, starting now.
Okay, good afternoon, Your Honor. So Raj, my client, is new to the town and he practically knows nobody except for Suresh, who is an old acquaintance. And earlier, it was informally agreed between Suresh and Raj that if at the time when Raj had to shift the house, if he didn't find any availability of new flats to shift, it can be possible to extend the duration of the stay. This was agreed informally, actually. And Raj has been searching for new flats to vacate for over 3 months, actually. And because he's a bachelor, there are less opportunities for him to find new flats. And Raj has been a very good tenant as he has paid rent on time all the time. And he abided by the rules given by Suresh to cook and eat vegetarian food. So I would like to emphasize on the point that Raj has been a good tenant, and informally it has been agreed that again, if at the time it's not available, he will give him an extension of stay. With this, I'd like to conclude my statement.
Thank you, counsel. Now we'll have the petitioner counsel cross-examine the defendant counsel and vice versa. Petitioner counsel, whenever you're ready.
A clarification, Your Honor.
Yes.
Is the fact about informal agreement taken into account by the judge?
So, as procedure usually dictates in lawyer up, some facts, if newly introduced and they're deemed to be reasonable, such assumptions can be incorporated into a case law. So the judge thinks whatever assumption has been put forth by the counsel for the respondent is reasonable enough to be incorporated.
So my question to the defense is basically that considering you said quote unquote informal agreement. For an agreement to have a legal basis, it should at least be you should have proof of the agreement, right? When you yourself concede that's an informal agreement, what's the legal basis for Raj to still stay in the flat when Suresh is asking him to leave despite 5 month notice? There's no legal basis for it. What is the legal basis that you propose?
Well, Raj and Suresh, they did agree on a written document prior to him occupying the house, and it is very much present with an advocate. No, no, not with an advocate, with a common friend. Yes, that is my answer.
Okay. Thank you, respondent counsel. Now you can pose your question to the petitioner counsel.
Yes, we had previously agreed on an informal agreement, as I said, and right now, why is the petitioner denying to give an extension?
I have a couple of responses to that. Firstly, notice even if the agreement is informal, like the agreement simply doesn't have a legal basis. But secondly, even in the assuming the agreement probably will have a legal basis, even in that case, we tell you that like even in that case, Raj has like Suresh has it's his own private property, right? So he has a right to ensure that he can choose who the client needs to be or when the client needs to vacate. So he has a legal right for him to choose whatever the reason may be. Like the reason simply doesn't matter here, right? Because the reason doesn't really matter here. There could be multiple reasons, but so we believe it's a very rational choice that the person is giving, and it's also very rational that the person is given 3 months prior advance. And despite that, if a person doesn't break it, and we believe that this suit is valid.
Thank you, counsel. So my question to the petitioner counsel is, from the case laws, from the case law, it is clear that the house owner has given the tenant a prior notice. Considering that the petitioner has multiple times emphasized on the presence, on the requirement of legality as far as an agreement is concerned, there has not been an established fact on by the side of the petitioner as to whether or not this was an eviction notice or just a notice to vacate. Could the petitioner please elaborate?
As in, like, to clarify whether it was
A notice of eviction or a notice to simply vacate?
Oh, okay. So like since it was like to told that like he needs to vacate by 3 months time, I think it's rational to assume it is probably an eviction notice because it is rational to assume it's probably an eviction notice.
Okay, thank you, petitioner counsel. Respondent counsel, my question to you is, the house owner is legally obligated to provide the tenant with a certain time frame, ranging from typically led by the legislation that we have 1 to 3 months. And considering the house owner Suresh here has given your client the maximum possible time as prescribed in our legislation, that is 3 months, do you think it is valid? Do you think the fact that your client still refuses to vacate holds any legal grounds?
Okay. Well, as they were friends already, Suresh would he partially agreed that he wouldn't make Raj, homeless or something. He would have a backup that he can stay at Suresh's house. So no, it doesn't have any legality, but this was an informal agreement agreed by both.
Thank you. Now, if we could please have the respondent counsel give their closing statement. Starting now.
Yes. So Raj, he is new to the town, and he knows nobody except for Suresh, and they are good friends. And both of them agreed that Raj would be given more opportunities if he did not find any other um, apartments to vacate. And yes, I strongly stand by my opinion, and I'm hoping for a positive response. Thank you.
Thank you, counsel. Petitioner counsel, if you could please give your closing statement.
Oh yes, I'll start in 3, 2, 1. Finally, notice the major contradiction in the defendant's case. Firstly, they say recognize this agreement was just an informal agreement. There's no formal base to the agreement. But when they needed it, when we asked them in a cross-questioning round, well, what's the legal base of the agreement? They just make up a fact and they contradict themselves and say, oh no. Now there's a written base to the agreement. They can't have the cake and eat it too. Right? They need to decide what kind of agreement it is, and we believe it's an informal agreement, like they said it in the first place. But secondly, they try to paint this very sorry picture of Raj not having any friends. Right? But notice, panel, this has no legal basis at all. Right? We literally have no legal basis. For our side, we told you we gave you a 3-month notice in the private property of Suresh, and therefore he has a right over it to decide which kind of tenant stays in it, and like who like he can decide who stays in it and who we can edit. Right? And this 3 month prior notice is the very basis of legality we prove to you. So we proved to you this. We proved this case simply on the legal grounds, but also the defense simply doesn't have a legal grounds for it, and they also have a contradictory case in nature. So they need to get the facts straight in the first place.
Thank you, counsel. I think that concludes this round. Can we have the next set of participants?
Yes. So the next set of participants will be Sai Darshan and Pranav.
All right. Can you guys please switch on
Sai
your
Darshan
audios
and
and your
Pranav, are you
videos?
guys here? Yeah, Sai Darshan.
Hmm.
Yeah, they both are here.
Okay, can we have can we give them case laws prior to 9, or do we only have to give them once after 9? Can someone from the organizing committee clarify? Can someone from the organizing committee clarify? Okay. Okay,
So
can you give them number 12? Yeah, give
uh,
them number 12.
Am I the respondent or the petitioner?
So, Pranav, you will be the respondent, and Sai Darshan, you will be the petitioner. Are you clear as to who the petitioner is and who the respondents are? So, Malini's uncle here is the petitioner because he files the suit, and the parents are the respondents because they're responding to the suit. So, are you clear as to who's who?
Oh, yes. Yeah, yeah, yeah.
Yeah, cool. You have preparation time of 3 minutes starting now.
so the prep time starts now, right?
Yeah, started already. I think, does that conclude that preparation time?
No, they have 45 seconds.
Okay, all right.
Does that conclude?
Yeah, I think that concludes your
Okay, should I go
presentation.
first?
Is my audio echoing for all of you? Or is it just me? I
It's
think
It's
echoing.
it's
actually
me.
echoing for me, but I don't know for others. It is echoing for me.
Yeah,
It is echoing.
It's echoing for me too.
yeah, not now
But
actually.
oh, it's perfect. I think it's fine.
Yeah, now it's
Oh, okay. Cool. So can we please have the petitioner counsel go on? You have 2 minutes for your opening statement starting now.
Yeah, thank you, George. So first of all, I'd like to point out the right to education in India. Right. So first of all, let's before I come to the right to education in India, let's first analyze the facts of the case. Yes, I consider the fact that they are an economically backward family and they are unable to send Molini to school. But then under the right to education, which was enacted in 2009, it states that everyone should ensure that each child in India gets quality elementary education irrespective of their economic or caste background. Clearly, the right to education in India specifies that irrespective of their economic background, the children should get their quality education. And so clearly, this is against the right to education of India. This is an open-ended case. This is a case to the advantage of my client, right? Because Malini's parents clearly violate the right to education of India. They are violating the Constitution of India. So clearly, they should be held liable. And clearly, if they don't have, they are not able to support Malini through economically, they can obviously send them to government school. They can obviously try and get funds for them. Or there are so many alternatives for economically weaker sections to get education, right? So clearly, what Malini's parents have done is against the right to education of India, and saying that it's a burden and finances itself shows they are not morally obliged towards their children, and they don't recognize the importance of education in children's life. So all I'm trying to say is my client is totally right in filing this case because Malini's parents have first gone against the law of India, which is the right to education, which clearly states that economic background doesn't matter and that children should be provided education. That's the first point. And second point is the parents didn't look at alternatives for economically weaker sections of the society to provide education to their children. So the lawyer also feels that this might be an excuse for them to not wanting to send their girl child to school. So with that, I'd like to conclude my statement.
Thank you, counsel. I think, Sai Darshan, can you mute yourself? Yeah, I think that's why I'm echoing. Mute yourself when you're not talking. Responding counsel, please start with your opening statement. You have 2 minutes on the clock, starting now.
Yes, sir. So thank you, Your Honor. First, let us consider the facts of this case. So, Malini is actually born with three brothers, and actually, considering in this exceptional situation, let's check the financial situation of the family. And actually, the financially, the family is not very sound in this case, and it's not that, of course, they don't want to send Malini to school, but let us consider this in the Indian marriage system where women is sent to another family and she's taken care of on the other side, but the three brothers on this side actually should take care of the family. Should take care of the family, and I think considering this, I think it is fair for the parents to not send their children, not send Malini to school. So I think it's fair on this case, and considering the constitution that has been violated, well, let us take this exceptional situation where, yes, in this case, let us take it as an exception that considering the financial situation, maybe if they could, it's not going to be possible for them to continue Malini's education throughout. Look at the future of this case. So look at the future of Malini, and if they are going to make their Malini study, and I don't think it's possible for her to continue for a very long time. She has to stop somewhere in between. So yeah, it's just to stop somewhere in between the education because, of course, the financial situation wouldn't allow her to continue further. So with that, I would like to rest my case.
Thank you, respondent counsel. Now we'll have the petitioner counsel ask the respondent counsel a question, and vice versa. Petitioner counsel, whenever you're ready.
Oh, yeah, thank you, George. You stated that they have three brothers in their family, and that's why Malini is not being able to go to school. So, are you trying to insinuate that boys' education is more important than girls' education? Isn't that highly sexist in your part to come to the court and make such a statement? How do you like to react to this?
actually
Yes, so I'm not telling that. Yes, so the brothers, the three brothers. All I'm trying to. My point is over here is that there are three brothers in the family, and Malini is going to go to another family after she's going to get married, and I think it's after that it's going to be the three brothers who will take care of their family, and I think when we take that point, it is fair that Malini is not provided with education. Thank you.
Respondent counsel, please pose your question to the petitioner counsel.
Yes, so considering the financial situation in this case, don't you think it's actually fair for them not to send Malini to school, considering that if we take a look at the future of Malini, somewhere in her future she has to stop her education considering the financial situation. So what's your take on that?
Oh, thank you for the question. So, first of all, I already addressed this in my opening statement. The right to education says that despite the economic situation of a family, the children should still be provided with education. So, I guess that answers your question in itself. And second, again, yeah, I guess that's answers your question. The financial situation of the family shouldn't come in between a child's education. So, yeah.
Okay, so petitioner counsel, my question to you is: you kept reiterating over and over again and again that the parents have violated right to education. Can you please elaborate as to how the parents have violated the right to education?
Yeah,
Please
so
elaborate the courtroom as to your understanding of Article 21A, that is the right to education, and how the parents have acted in violation of it.
yeah, so clearly in the facts of the case, it says that they refused to send Malini to school to provide some basic and provide some basic. Wait, so they say it provides that they refuse to send Malini to school, considering it's an extra burden on their finance. And clearly, the right to education states that despite economic backgrounds of anyone, the children should still be should still get the quality education they deserve. So clearly, this is a violation of the right to education of children.
Uh, Thank you, counsel. My question to the respondent counsel is: every child in India is guaranteed the right to a safe environment under the Juvenile Care Act. When such is the case, do you think the act of Malini's parents not educating her, despite educating their sons, is creating an unsafe environment for her and thus in violation of the right that she so fundamentally holds under the Juvenile Care Act?
Yes, so I would not call that it is unfair for her not to get education because as I said before, even if Malini is going to get educated at first, considering the future and the parents' financial situation, I would say that somewhere in the future, her education has to come to an halt. And considering that in the Indian marriage system, of course, Malini is going to get married to another family, and she's going to get taken care of, a good care, in fact, by the father-in-laws and in-laws. But the three brothers over here, of course, they got educated, and they're going to take care of they're going to take care of the family afterwards. So I think it's fair for them to get educated over there.
Thank you, counsel. If we can please have the respondent counsel start with their closing statement. The respondent counsel, start with your closing statement.
Yes, so I would like to say that let us not make this as an unfair statement by saying that Malini is actually not provided education as per the constitution holds for her. But let us consider the financial situation that the family holds over here. Like she is not so a family is not so sound in the financial situation, considering their financial situation. So let us say that it is unfair to impinge that she getting not educated is actually unfair. So yeah, with that I like to conclude.
Thank you, counsel. Petitioner counsel, please go on with your closing statement.
Oh, yeah, thank you, George. So first of all, the respondent stated first that there are three boys in the family, and so the family is concentrating on their education. And second, the respondent stated that the Malini will go to another family and will be taken care of, and her education will come to a halt at some point. This is just blatant sexism in the courtroom, and I feel it's highly irresponsible and sexist for the respondent to come and make such statements in the first place. And clearly, the law does not discriminate between men and women when it comes to education. So that's the first point. And second, as I said, the family has violated the right to education, and this is an open-ended case in the advantage of my client. So clearly, Malini should get education, and Malini's parents should be held liable. Thank you.
Thank you, Counsel. And Petitioner Counsel article right to education is not against a private entity. You can't sue the parents with the right to education. Right to education just places an obligation on respective state governments to ensure that every child gets access to education. It's not a means to sue the parent of a child for depriving them of education. Anyway, we move on. The next set of participants, if the organizers could please call them up.
Yes, so actually, I think it's Samyukta. She doesn't have any opponent actually. She has the.
That's fine. That shouldn't be a problem. Can we? Uh, okay. Can we have case law? Hmm. Can we have case law 5 for
Actually, I
Samyukta?
have one small doubt.
Yes.
Yeah,
Yes.
so even though the right to education is not will not be binding on the parents, it's still a political and moral force to send them to education, right? So
Yes, but it doesn't create a legal standing, and it's better to avoid quoting a legislation that you're not entirely sure concerns which party. So in this case, the obligation is on the government, and the petitioner using it against the parents does not create a legal standing of any nature. Anyway, so can you please
How
have?
was it that I go without a partner? How will it work right now?
So we're going to give you a very one-sided case. That
Okay.
is, it's very clear as to what your stance is going to be,
Okay.
and the only difference is instead of you having the points for cross questioning, you will be evaluated more for the structure of your argument. So it makes it a little easier for you because you don't have a partner to go up with, and we're also giving you a very one-sided case.
Sure.
So this will be your case. You will be representing the people in the village.
Okay. Sure.
Yeah, go on. So you have 3 minutes preparation time. Starts now. Does that conclude her preparation time?
Uh, yes, Your Honor. So
Okay.
I'm.
So
Yeah.
you have 2 minutes for your opening statement, which start now. Please go on.
Okay, 3, 2, 1. Yes. So, uh, by looking on the facts of the case, I am able to relate this particular case with the famous landmark judgment called the Bhopal gas tragedy, which is a very identical and a landmark judgment made by the Supreme Court. So here, I think it is a negligence of the factory where it had resulted in the in the physical aspects of the people in the village, where the facts of the case clearly says that several people in the village and workers losing oxygen and their lungs getting affected. So I think oxygen is the basic necessity for survival, and also a right to life is also getting diluted in this particular case. So I think so I think apart from paying compensation or taking in charge of the financial aspect of it, here right to life and basic fundamental principles, which starts with the in the constitution at the beginning, which is famously called the preamble, is getting diluted. So I think the people in the village are having a very tough time facing with their financial aspect, with their household, as well as a health condition. So I think the whole responsibility is on the hands of the factory, and the honorable judge must look into this particular aspect of the case.
Thank you, Counsel. The first question that I want to pose to you is, considering that a gas leak is not intentional, right? No company would intentionally cause a crack in their factory and hence lead to a gas leak. When such is the case, when there is no intention to cause it, how do you think you can prove liability?
Um, but then the factory must be responsible and should have checked upon all the aspects of their chemical reactions, or their pipelines or whatever it might be. But here the gas leak has happened, and it had affected the population of the village, where only from the factory's point of view, it might have been an negligence, or it might have been a very small accident, and I'm sure that it did not happen intentionally. But the final point of this particular incident is that it had taken a call upon the lives of the people, where the constitution also clearly prescribes that no one has a right to take other person's life. Here, I think the elders and the adults who would be able to manage with the health condition. But then in the villages, the diarrhea, malaria, water cloggings, everything um, of, adds up to the point. And especially if we could imagine the particular gas leak getting mixed with water, food, and everything, I think the infants, a lot of old people will be severely injured, and
Thank
their
you,
physical condition as well as
Counsel.
the mental condition will take on
Yeah,
worse.
so Counsel, you mentioned that that it violates constitution provisions. How do you think this violates Article 21, that is right to live? How do you think you can correlate this with right to live? Since you've also mentioned the Bhopal gas tragedy case, it's very closely related. Do you think you can draw a parallel between the violation of the right to live and this particular case law?
Um, I think the Bhopal gas tragedies, facts, and the case are more in detail and prescribes at every point of the facts upon how it had affected the people in the village. But here, looking on the facts, I think the cause of death polls are more with aspect to the leakage, and where a lot of small children might have been affected the most. So with that particular aspect, and which just came into my mind, I just drawn a parallel saying that right to life have been violated.
Thank you, Counsel. Now, if you could please give us your closing statement.
Okay, I would just like to. My closing statement would be that at the government the government as well as the factory must not repeat the same incident again, and must also look into many compensation or any other medical expenses or treatments which they can uh, take it under for the affected people in the village, because by seeing the prima facie the factory is at fault, and they must have a particular moral value, and also upon whatever I said previously. Thank you.
Thank you, Council, and very well done. You were right with the whole. Despite not having an intent, they still have a liability. That's something called absolute liability. So well done. I think that concludes our event. Does it? Do we have any other participants? Can someone from the organization and please intimate? Okay, I'm going to
Yeah,
assume
the
that.
event, yeah, it's over.
Yeah. So yeah, that concludes the event. So when do you need the finalists by?
Yeah, it's up to you whenever you tell.
Okay, and how many finalists do you need?
I guess we'll decide that in the chat box, WhatsApp.
Okay, all right. I think that's it. Thank you so much, everyone, for participating. I think the organizing committee will let you know about the finalists and how the finals will take place going forward and all the other details.
Thank you